Professor Namyong Lee's commentary, long, are Articles 82.8 and 250 of South Korea's Public Official Election Act consistent with global standards in the age of AI? South Korea has now entered an era in which artificial intelligence technologies are fundamentally transforming the structure of political and electoral communication. Generative AI, AI avatars, automated video generation, and deep learning-based content production technologies have dramatically lowered the cost of producing political messages. However, amid these technological changes, an important question arises. Is South Korea's election law framework responding appropriately to this new environment? In particular, Articles 82.8 and 250 of the Public Official Election Act are representative provisions that directly conflict with the freedom of political communication in the AI era. Let us first examine Article 82.8 of the Public Official Election Act. This provision regulates election campaigning conducted through the Internet and information communication networks. Its basic purpose is to prevent the spread of false information and to maintain a fair electoral environment. However, when we look at the actual operational structure of the provision, it carries a strong element of prior regulation. Under this article, the National Election Commission may request the deletion or blocking of Internet postings, and portal and platform operators are required to cooperate with such requests. The problem is that these measures may be taken based on the judgment of an administrative agency before any judicial determination is made. This creates a structure in which an administrative authority can directly control issues of freedom of expression, which are extremely sensitive in a democratic society. From the perspective of global standards, regulations on election-related expression are generally designed around the principle of ex post accountability. In the United States, political expression is considered one of the most strongly protected forms of speech under the Constitution. In Europe as well, political speech enjoys a very high level of protection. Even when false information or defamation becomes an issue, responsibility is typically determined through judicial procedures. By contrast, Article 82.8 in South Korea has been criticized as excessive regulation because it allows administrative authorities to directly intervene in online political expression. This problem may become even more significant in the age of AI. With generative AI technologies, video, audio, and image content can be produced extremely quickly. In such an environment, attempting to control individual pieces of content in advance through administrative regulation is not only unrealistic, but also ineffective. Rather, it may lead to the suppression of political expression. Despite the transformation of the technological environment, the regulatory framework remains designed based on the media environment of the past. This is a fundamental problem. Next, let us examine Article 250 of the Public Official Election Act. This provision establishes the offence of publishing false facts and allows criminal punishment for publicly spreading false information about candidates or politicians during elections. The purpose of this provision is to prevent the spread of false information during the election process. However, in practice, its application has repeatedly generated conflicts with freedom of expression. The most significant problem is that the standard for determining what constitutes a false fact is highly ambiguous. Political statements often involve a complex mixture of factual judgment and value judgment. Policy evaluations and political criticism may lead to different conclusions about factual accuracy depending on interpretation. If such areas are expanded to the scope of criminal punishment, political debate and criticism themselves may become suppressed. In addition, the criminal punishment-centered regulatory approach is relatively strong when compared with international standards. In many countries in the United States and Europe, criminal penalties for political speech are applied only in very limited circumstances. Instead, issues are often addressed through civil liability, the guarantee of the right of reply, and the expansion of information transparency. However, in South Korea, the offense of publishing false facts can lead to imprisonment, which reflects a relatively strong level of criminal regulation of political expression. In the age of AI, these problems may become even more complex. For example, if false information appears in AI-generated content, determining the responsible party becomes a critical issue. Multiple actors may be involved, including the content creator, the platform, and even the developers of the algorithms. Yet the current legal framework does not sufficiently reflect these technological realities. Ultimately, while Articles 82.8 and 250 of the Public Official Election Act aim to protect the fairness of elections, they may be criticized as regulatory structures that do not sufficiently consider the digital political environment of the AI era. Electoral fairness and freedom of expression are both values that must be protected simultaneously in a democratic society. Therefore, regulatory policy must seek a balance between these two principles. Future discussions on revising South Korea's election law should be guided by three principles. The first is the principle of technology-neutral regulation. Rather than regulating specific technologies directly, regulation should focus on harmful outcomes such as fraudulent manipulation or deceptive practices. The second principle is transparency-centered regulation. If political content is generated by AI, it should be clearly disclosed so that voters can make informed judgments. The third principle is ex-post accountability. Strengthening post-fact responsibility mechanisms is more consistent with democratic principles than adopting prior censorship-style regulation. For South Korea's democracy to continue developing in a healthy manner in the age of AI, the legal framework must not fear technology, but instead design institutions that balance technological innovation with democratic values. The Public Official Election Act should also be re-examined in this direction. Thank you for watching Professor Namyong Lee's commentary long.